just say hello and let's go. Okay. All right. Hello, everyone. Welcome to Out of Crazy Town, your guide to divorcing a narcissist. I'm super happy to have attorney Adam Schanz on today. He's going to discuss a topic with us that I get a lot of questions about. I know in California, there's a lot of confusion around this topic, and basically from a legal standpoint, what it takes to win a move away in family court. So Adam, thank you so much for joining us today.
Yeah, thanks for having me.
I know you're a California guy. Did you grow up here?
I did. I grew up in the Central Valley, made it out of there over to the ocean and haven't left since. So
I know. Well, you're a surfer, right?
yeah, can you
Yep.
tell I'm tan?
Yep. I can tell you've been you've been out recently. I
Right.
know my daughter surfs, so we have lived the surf life. We're lucky to do that, like you said,
Yeah.
being by the ocean. Because I know you went to UC Santa Barbara for undergrad. Is that right?
Yeah, that's right. I'm a gaucho.
Awesome. And then you did your you went to law school at Pepperdine.
Yep, I went to Pepperdine. While I was in law school, I clerked for a family law judge
Okay.
during my first and second year summers, and then third year I worked basically in the courthouse for the judge as well. So I've always done family law from early on, and I liked it, and I just got into it right after I graduated and passed the bar. So
Awesome. Well, the reason I asked you to speak on moveaways is because amongst your peers, you're known as at being good at this stuff. So again, I'm super happy to have you on and have you share your expertise with us. And I also want to let everyone know that Adam has been recognized as a rising star by super lawyers in 2009, 2010, 2011, 2013, 14, 15, 16, and 18, and was recognized as a super lawyer in 21 and 22. So he's really good at what he does. He's here in the South Bay office in Manhattan Beach, correct?
yeah, that's right.
Yep, in the Los Angeles area. So anybody who does want to look him up, you're A Schanz Law, right? ASC. Tell us your website?
Yeah, it's ASCHANZLAW.com. Just my name.
Awesome.
Yeah,
Thank you. Thank
first
you.
initial.
All
Yep.
right. So let's dig in. I think maybe the first thing I want to discuss is what is the criteria as far as a family law judge looks at when they're looking at a move away?
Yeah, it's a really broad question. So I've done a bunch of moveaways throughout my career. Done move away trials, done move away hearings. And I guess the initial answer to that is it depends on the facts of the case and where the case is in the process. So, for example, if it's just an initial separation of mom and dad and there are no custody orders, then there's one legal analysis that goes into play. That's basically the best interest standard because you have to determine from the outset, hey, say mom is moving out of state for a job and there are no custody orders. Well, in that case, the judge's job is to look at what is in the best interest of the minor child or minor children. That one's easy, right?
Okay.
It's very broad. I mean, it's not easy. First of all, backing up, it's very hard to be a judge on a move away case
Mm,
because it's very much an all or nothing type thing. I have heard people in the community, family law community, refer to move away cases as kind of like the oncology ward of law because um, children suffer. They're going to be away from one of their parents more than the other. And
yeah.
even the moving parent inevitably is going to not see the child for some period of time as well. So it's really hard and stressful to make these decisions. So I don't want to trivialize it and say that that one's easy. I mean, what I mean to say is a best interest standard is very sort of broad and general, and the court can consider basically anything, right?
Yeah.
So that's the first scenario, initial custody order. Here's where it gets more tricky. So if you have a current custody order and it's a final custody order, meaning a permanent Montenegro order, we call it in California, where basically to change custody, you have to show a substantial change of circumstances
Okay.
in order to even modify the order. And that's an initial threshold showing you have to make. Certainly, someone moving out of state would qualify as a change of circumstances. But then you get into two separate legal analyses based on what is the custody schedule in the
Mm,
final order, right? And it's very different in terms of what the court's going to look at. So, for example, well, there's two scenarios. First scenario is shared custody. The second scenario is the one of the parents has primary custody or sole custody, and the other parent has visitation or maybe even no time with the child.
mm,
So based on those two types of orders, the legal analysis is very different.
okay. Okay.
Um, so I mean, I can run through it real quick. The the shared custody order is almost the tougher case for a judge,
Okay.
because the these parents and this child is spending frequent and continuing time with both parents. And inevitably, if a parent moves, then that time will be, at least the frequency alone will reduce. And that's
Sure.
always bad for kids because all the research says that children should see both children, relatively often.
Hmm.
Um, so, I mean, I have cases and I've had cases where someone moves out of state or out of the country, and the child ends up living with one of the parents and going to school there, and then essentially spending all of their vacations, like summer break, winter break, spring break, with the other parent.
Hmm.
Um, and it's not ideal. The child doesn't get to see either parent regularly enough, but that's the best we can do under those scenarios. So, under the shared custody situation, the court does what's called a La Mouche analysis.
Okay.
It's a famous case in California. It's spelled LAMUSGA. Everybody can look it up
Yeah.
online. The famous La Mouche factors.
Sure.
Um, but essentially, it's sort of a best interest analysis. The court's going to look at primarily what has been happening and how do you preserve the stability and continuity of the custodial arrangement. And it's going to be hard to do that, depending on the distance of the move, how old is the child or the age of the children, how good is the child or children's relationship with the parents.
Mm,
And I think one of the most underemphasized factors in all this move away jurisprudence is which parent or parents is going to facilitate a good relationship between the children and the other parent.
yes.
Because I have seen move away cases decided on that factor quite a lot, where there's an ongoing pattern, perhaps, where one parent is not facilitative or
Mm,
actively thwarting the relationship with the other parent,
hmm.
and the child. And that can end up being a really big factor. So what I always tell people is, hey, you want to move, you better make sure you're being a real good co-parent.
Yep.
You better be an all-star co-parent. You better go out of your way. Oh, well, the other parent's very difficult to talk to. You know
Yep.
what? They make email, they make Our Family Wizard, they make text message, put it in writing, show how good of a co-parent you are, share information, try to get along, because that's going to maximize your chances of moving if that's what you want to do. And,
Absolutely.
and then the same token, if the other parent is moving and say my client is making a play for the children to stay with him or her,
Hmm.
same advice. Be the all-star co-parent. Go out of your way, because not only just for strategic move away stuff, but also because the children benefit from it,
Right.
right? Children benefit from parents getting along and being all-star co-parents. And say the parents don't get along, that's fine, but Shaq and Kobe didn't get along, but they also played on the same team and they did a great job, right? And they won games. So I always tell people that. So that's the shared custody. The other scenario two, is if one parent has primary custody. Well, what is the law there? Well, that's a different one, and it's kind of vague in the case law, and a lot of people fight about this. So, say dad has every other weekend and Wednesday overnight, and
Okay.
mom has the rest of the time. Okay. Well, is that sole custody for mom and visitation for dad, or
Mm,
is that shared physical custody? And shared physical custody, so you do la mouche, or is it sole physical custody, so you go down the other avenue?
I
And
see.
there is case law on it, but it's a little vague. And then bleeding into that is, well, okay, maybe dad is not exercising all his weekend custody, or maybe
Yeah.
he forgoes his Wednesday nights because he goes out with his girlfriend and has steak dinners on Wednesdays, or
Hmm.
whatever it is. What are they actually doing in real life versus what does that piece of paper say? Because that could factor into what the court decides is the legal analysis. So if it's a true sole physical custody to mom under that scenario, because
Hmm.
maybe dad's foregoing time,
Right.
then mom would have a presumptive right to move under Family Code 7501. And
Okay.
it doesn't mean mom can just pick up and move, though. She still has to go to court and get a court order permitting her to move and relocate the child. And just to be clear, we're talking about moving the child. Obviously, mom can
Right.
move anytime. There's no restriction on her
Right.
whether or not the child can move. So under that scenario, even though mom would have a presumptive right to move under California law, dad still has an opportunity to try to show that there would be detriment to the child if the child were to be allowed to relocate with mom.
Sure.
And what is detriment? Well, maybe mom's not the all-star parent, right? Maybe mom is really kind of a terrible parent and doesn't really get along very well and doesn't share information. That's one factor. And maybe another factor is the child has a whole support network in the current location, like a therapist and, great support system, friends, teams, sports teams, whatever it is. And dad says, well, look, the whole life is here. It's detrimental for the child to relocate with mom.
Right.
And there's a whole litany of cases that are published decisions in California where the non-custodial parent has been able to successfully prevent the child from relocating. And in fact, La Mouche was a case where basically the custodial parent was disallowed from relocating the child. So, but
Ah,
under the second analysis, the presumptive right to move, if the non-custodial parent is able to successfully show detriment, then you shift into the next analysis for the court, which is essentially a best interest analysis. And you know, there's a whole bunch of factors and cases that say what to look at, but at the end of the day, all these move away cases are very fact specific, and it's really hard to give really good advice without knowing more about what is the history between the parents and the child, what is the parenting schedule, how, there are so many factors that go into it,
sure.
and each case is different. But what isn't different and what's very important is to figure out which legal analysis applies, because that's going to guide your presentation of evidence to the court on a move away.
Absolutely. Absolutely. And so what I'm hearing you say is if you even think that this is something you want to pursue, obviously you're going to want to sit down with an attorney and decide which avenue you're going to take, because it can look so different. And I love what you said, because obviously I am not an attorney and I do not give legal advice, but what I do talk about with clients is what I see and what they should, what I see people needing to usually talk about their attorneys with. And so all of those rules apply. Yes, pretend a judge is reading everything you write to your co-parent. We often talk about strategy that you better start, say it is mom that wants to move away, send in dad photos of kiddo when they're doing important things. If you're with the kid, child more often. I mean, we come up with all kinds of stuff, start making birthday cards with them for dad, start, communicating everything that's going on, show that you keep the other parent in the loop all the time. If
Right.
you're, and that you're amicable and that you're looking for solutions and that you're not, and it's hard because I only deal with high conflict situations. And so often I get, well, oh, the more I communicate with him, the more of a jerk he is. And then every time I tell him something, it opens me up to, more issues with him. Or I don't want to tell him when all the play dates are because then he shows up. I'm like, you know what? I always say your pro you column needs to be 2 or 3 times as long as your whatever he's going to say that's bad about you, or whatever you have bad to say about him. So the
Right.
judge is going to look more at the pros, what you're doing
And
positively.
and a child should be so lucky to have both parents show up to a sporting event or a
Right.
I mean, even if they're not getting along, for the child to see both parents there, supporting them, I mean, that's really because all the research shows that children of divorce are definitely impacted by it
Yeah,
in different ways. And, as a co-parent, your biggest job, I think, in my opinion, is really supporting the child and trying to limit any fallout,
yeah,
whether, not just divorce, but also, non-marital couples that split up, same
sure,
scenario, because
sure.
that's the biggest job, irrespective of moveaways or custody battles or anything else, Um, the other point though, and this is the last thing I'll say about the law, I'm a lawyer, so I geek out on the law, but
No, this is what we need to know. Please go.
yeah, in this situation where if you're able to convince a court that you are a sole physical custody parent, where you have the presumptive right to move, then it becomes a lot easier to move because even if the court is persuaded that detriment has been shown, there's some ambiguity in the law, but whether or not the non-custodial parent is entitled to an evidentiary hearing to present evidence is sort of up in the air. There's a
Mhm.
famous case called Brown and Yana, where it essentially discusses whether an evidentiary hearing is permitted for the non-custodial parent under that scenario. And the facts of that case were really sort of an outlier, I would say, because that parent, who was the non-custodial parent, basically had no legal custody and no physical custody,
Ah,
a very limited visitation. So, but definitely didn't have legal custody. And I think that was a big one. So the case went all the way up to the California Supreme Court, and they
wow.
basically ruled on those facts because the non-custodial parent didn't even have legal custody and wasn't seeing the child very often, if at all, that in that case, that parent was not entitled to an evidentiary hearing. So what does that mean practically? Well, under that scenario, the moving parent was basically granted the right to move without going even through the court process and navigating through the litigation system, which is nice, right?
Right.
So, because it's expensive and time consuming. So it's
Yeah,
almost sort of like a backdoor immediate, don't pass go, you get to move type thing.
sure.
So that's always the best case scenario for a moving parent. But it's very rare that you have a case where a parent doesn't have shared legal custody and at
Sure.
least some visitation rights. So almost every move away case falls into this law mouche type place where the
Hmm.
court's supposed to consider all these different factors. But then on top of it, there's other things. Will the court consider whether or not this is a good faith move? Or is the moving parent doing this in bad faith to try to thwart the relationship between the children and the non-moving parent? And there are published cases where the court determined that did happen, and therefore the move is not happening, and the children stay here. And good luck, moving parent, but children stay here because you're moving in bad faith. Um, the court also will consider any type of economic factors at play. For example, if the moving parent is taking a job in the state of Washington because it's a good paying job with good benefits and it's better than what they have here, that might be a positive for the moving parent. But if
Right.
the parent is moving to Washington to, join a commune and live in a teepee and weave baskets and not work and giving up this great career here in Los Angeles,
Right.
court's going to consider that too. But the one thing for sure that the court has to do, and this is emphasized throughout all the cases, is the court has to assume that the parent who's moving is actually going to move. So in other words, the court won't say, well, we're not sure you're going to move, but if you do, here's one order, but if you stay, here's the other order. And essentially it has to issue a decision based on the moving parent actually moving.
Okay.
So it's not going to say, well, mom, I know you say you're going to move, but I'm going to abstain right now and not rule because it doesn't seem like you're going to move and you're not sure when you're going to move. The court actually has to issue a decision and make
Okay.
the call. And that's why it's so hard being a judge because you can't punt, right? You can't say, well, man, maybe for another day, if and when it's actually relevant. Well, no, this parent has filed this request. Here's the evidence. you got to make that hard call about where these kids are going to live.
Mm-hmm.
And that's hard, you know?
So this explains a lot, because I had a client who had a case who had asked for a move away. The judge decided it was in bad faith.
Mm,
It was something that she had no clue, no expectation of, I guess. And so they had sort of, from my understanding, put in this request that, if the judge granted the move away, great, they'll move away. But if not, they'll just keep the custody status quo,
mhm,
and she would stay. Well, it sounds like what the judge did was what you described, because even though dad did not want full custody, she
mhm.
gave dad full custody. And so I guess everyone's sitting in the courtroom with their jaws on the ground, including dad, because he didn't ask for full custody. But she said, well, I'm assuming you're moving away, so dad gets full custody, have a nice life. And, and she was in shock. She walked out of the courtroom and had, you know, like probably 60-40 in
Yeah,
her, favor custody, and now has none. And like, and what's my next legal move? So
yeah.
we were all really stumped at that one, but that explains a lot, Adam.
Yeah, and going into it with that expectation in mind that the court is absolutely going to modify custody no matter what. And again, it's based on facts of the case. It sounds like in your situation, obviously I have no knowledge of that case, but
Right.
the court, in the court's wisdom, decided that mom was not the all-star parent, and for whatever reason, whatever the facts were, decided that maybe the child or the children were suffering because of that, and elected to change custody based on that, regardless of whether mom was moving or not. And that does
Mm-hmm.
happen. If the showing by dad was so strong that mom was, essentially hijacking the co-parenting, or hijacking, bad mouthing dad, or
Mm-hmm.
whatever it was, um, judges are pretty quick to, if they get a whiff of that in the evidence, they're going to change custody.
Sure.
And that's why I think it's so important to have good professionals involved, like yourself, and a good lawyer who can really help behind the scenes plan and prepare a client going into one of these things. Because I always say, with a move away, you really can't unring the bell. Once you
Yeah.
file that request, that train is going down the track, and
Yeah.
you're going to get some orders. So you got to get ready, and you got to marshal your evidence, and basically be as prepared as you can.
Sure, sure. And on the flip side, I had another case where she did move away, and I said, "What do you think the factors were?" And she said, it was the pro column. She said, "I just made sure that it was a baby, and I made sure I informed dad of every single thing. First solid foods, first crawling, first whatever, first, like,
Mhm.
birthday cards, whatever it was, like constant um
Yeah.
informing dad and involving dad in everything, even though he wasn't showing up for the kid, did it anyway." And judge said, "You're a mom that sounds like you're going to keep dad involved in kid's life."
Yeah.
And so
And
I'm comfortable with this.
and think about it this way. Here, let me give you a hypothetical. Say you have two parents that have 50-50 custody, and one of the parents is taking a job in another state that's demonstrated to be a good job. It's a good faith move. Everything else is equal, though. They've had 50-50 custody, but one parent goes out of their way to be a good co-parent, that all-star co-parent who's always communicating, always supportive, always paying half of uninsured medical bills, always paying half of extracurricular activities, always doing things for the child. And the other parent is not doing those things, right?
Yeah.
All other things being equal, which parent do you think the child's going to live with after that trial?
Yeah. Yeah.
Right?
Exactly.
So it could
Exactly.
totally carry the day. And that's why it's so important for people to get past whatever drama and stuff they have with their ex-partner or their co-parent, because
Yes.
it really is very, very important, in so many ways.
Yes. And like you said, if the side effect is that they just kind of start to get along better, whether whether you sort of want to or not, I guess is what I'm trying to say, then great. Then great. If that's what the kid feels, and if the kid sees, then great. And I
Yeah.
get that you don't necessarily have to feel that, or or love this other person, but as like you said, if the side effect is that the child's feeling that, then
Yeah,
that's
but
great.
it can also be a self-fulfilling prophecy. I've
Yeah.
seen cases where parents were like oil and water, and then one day one of the parents started doing the right things, and the other parent says, "Wow, this is nice. I'm going to start doing the right things and getting along with this parent." And 5 years later, they're getting along like they've never gotten along before, right?
Yeah.
Because it took someone to offer that olive branch or whatever it was,
Right.
even if they were doing it in a strategic way that they
Right.
thought was helping them in litigation or whatever. I mean, it can only be good. So
Yes.
that's why it's, as a practitioner, it is very frustrating to see time and time again, either my client or the opposing client not be able to co-parent in a way that's healthy and good for the
Sure.
children, because it's just never good
Yeah.
on
Yeah.
all levels.
Right.
you
Right.
know
Never good. And so it brings me to my next question you kind of alluded to, but and I think that I'm quoting the right code, 3042A. I hear a lot of people say, well, my child's 14, can't they just choose? And so I want to elaborate on this because I I know I sent you an email and I said I feel like this code's kind of BS, because I'll tell you why. And this kind of speaks even just to custody, not moveaways. But I know, if, like I said, tell me if I'm quoting the right code, 3042A. If a child's at least 14, the law allows a child to stay a custodial preference unless the judge believes doing so would be detrimental. So in the cases I see, even if judge does listen to kiddo 14, 15, 16 years old, if the other parent, say, wants 50-50 and child said, no, I'd rather live with one parent Monday through Friday and go to school, I'll see the other parent on the weekends. That's what I would like. That's better for me. If parent B says, no, I want 50-50, I don't care. To me, the judge doesn't give a shit what the kid thinks. He gives the parent what they want 100% of the time. That's what I see. But again, I feel like I have a very specific clientele, so what are your
Yeah.
thoughts on that?
I mean, I've dealt with this issue a lot. I've had a lot of 14-year-olds, even 12-year-olds or 16-year-olds, you name it. And the way it works nowadays down at the courthouse is, if there's not minors counsel involved, and one parent wants the child's preference to be heard, then what the court will inevitably do is order either a parenting plan assessment 1 or a parenting plan assessment 2, which basically means the child comes into court, talks to a social worker who's employed by the court, and expresses their preference and the reasons why they have that preference. And then that social worker will then in turn probably write a written report. If not, will provide an oral report to the court on the record in front of the parties and their lawyers. And depending on how well reasoned and how um, informed and mature that child's opinion is, the court will either consider it or not consider it. And again, very fact intensive based on the facts of the case. It may be that there's a shared custody situation and the child wants to live or spend more time with one parent over the other parent. And what are the reasons for that? Is it because this parent that I don't want to live with as much has more rules? I have to go to bed by 10 o'clock at night and I can't eat junk food, at
Right.
10 p.m. Or
Yep.
is it, hey, that parent is never there, and when they are there, they're drinking a bottle of wine, and they never get me to practice on time, and so what are the reasons why that child has that opinion? And that's
Mm-hmm.
really what the court wants to hear, and the social worker's trained in getting to that description for the court. And ultimately, I mean, I have seen preferences of children being incorporated into court orders,
Okay.
but at the end of the day, it doesn't carry the day. I mean, the statute says that the court shall consider and give due weight to. So the court has to consider it, but never is the court ever going to basically just rubber stamp it.
Okay.
And the same goes for, if you have a custody evaluation and you have an opinion from an evaluator who's got a PhD and is really smart and writes an 80-page report, the court doesn't rubber stamp that either at the end of the day if there's a recommendation. I've seen countless times where a very expensive, well-reasoned child custody evaluation report and recommendations is not adopted by the court, and it's rejected for various reasons.
Mm-hmm.
So, and that's a PhD. That's not a 14-year-old. That's someone who's trained in this, right?
Right.
So, and ultimately, that's how our system is, which is that the person with the black robe makes the call,
Yeah.
right? It's not the kid, it's not the PhD, it's not the lawyer, it's not the minor's counsel that represents the child. The person in the black robe, their job is to hear all the evidence, weigh it, and apply the law to the facts in their
Sure.
view and make the call. So
Do you see maybe this is hard to answer because, like you said, specifically when we're talking about move away, circumstances can just really range from one end of the spectrum to the other. But do you see a big swing in the way judges rule just based on like their personality? Because I kind of what I hear you saying is it's really a crapshoot. And that's what a lot of clients see. Like there's no rhyme or reason. They're trying to follow rules. They're trying to like do things that are best for their case. And at the end of the day, they might not listen to minors counsel. They might not listen to the social worker. And it just all seems so random. Like, what are your thoughts on
no,
that?
it's a really good point that you raise. I tell people, look, no lawyer can guarantee an outcome or a result for a client. And if they do, you're probably talking to the wrong lawyer.
Yeah.
Because when you go through this process, there are so many uncertainties and unknowns. And you just don't, I mean, you might be in front of one judge and then your case gets transferred to another judge right before the trial starts. And so you
Yeah.
have a whole new judge hearing your case. And so there's so many factors at play. And it's really hard. And that's why I think one of the big things that people have to consider are forms of alternative dispute resolution, like mediation, settlement conferences, things like that, because you can have control over your outcome in that process. And if you have the person with the black robe on make the decision, you have zero control. And
Yeah.
oftentimes that person doesn't know you, doesn't know your co-parent, doesn't know your child. They try to get to know them and they try to make the right decision, but it's a really heavy burden and a stress on a judge to try to make that decision. And frankly, it's probably much better made by the parents. And that's why going into an alternative dispute resolution process is almost always better. The problem is you have cases that that's not going to work, right?
Yeah.
Like a move
Yeah.
away. No one is going to go into that and say, oh yeah, I want summer, Christmas vacation and spring break, and you can have the rest of the year. Why
Yeah.
would they agree to that if they think they have a reasonably good chance of having the opposite?
Yeah.
Because it's more time with their child or children. And so there are certain cases where it's really tough to reach a resolution informally. Um, but yeah, court is rife with uncertainties.
Yeah.
And it's very difficult, even if you have the best lawyer, the best accountant, the smartest judge, you never know what's going to happen.
Yeah. And there is never really justice served, or I shouldn't say justice served. It's just you're not ever going to get everything you want. I've never seen that happen,
Right.
or very rarely in a case, or if it did happen, it was literally 10 years in court. I know of one woman who kind of got everything she wanted, but it took 10 years to sort of prove what she was trying to show the court. And I hear that a lot, like, how do I make the judge see fill in the blank? And I'm like, oh boy, that
Yeah.
is, I don't, you probably won't.
Yeah.
Even if you have good reasons and the other parent is very scary, it's going to take a long time, a lot of resources, and buckle your seatbelt.
Yeah, I mean, people have this perception if they have no familiarity, especially with family law court, that hey, this is America and we have this great judge and court system. And I watched Perry Mason, and right always wins and wrong always loses. And it's not like that. It's
No,
really not. There's a lot
no.
of nuances. There's a lot of things that the law has that maybe people don't think make sense. And you know what? The law doesn't make a lot of sense sometimes. There's a lot of gray areas. There's unpredictability, uncertain outcomes. And it really can come down to, in your example you used earlier, maybe mom sent one really crummy text message to dad, or mom sent a text message to a third party saying bad stuff about dad or whatever it was. And maybe the court just looked at that and said, wow, I saw one of those, so there are probably a bunch of other times where it wasn't written but it was said, so I'm going to
Mhm.
make this decision. And you don't know what's going to trigger someone who's a judge in
Right.
situations like this.
Right.
So it can be quite a challenge going through the process and trying to be right, because if you're there trying to be right and just on principle, that a courtroom's not the place to do it
Yeah. Yeah.
because it's right does not always win. And in fact, right
No.
can lose, right loses sometimes, you know?
Right. Right.
I'm
Does
sure you've
lose.
seen it.
Yeah,
Yeah.
absolutely. And you said something earlier I wanted to come into, because even if you did say win that move away, I'm sorry, there's people say to me, wait a minute, he might get the kids for a month and a half in the summer. And I said, yeah, that's because they're trying to equal out, time shared with, or no, you might not see him ever any spring break. He might get every spring break or every whatever, So yes, that is a very stark realization, I think, for
Yeah.
some people. Like, moving away doesn't mean just the kids are with you all the time. They're gone from you for large chunks of time so that they can get that time with the other parent.
And
So
add into that scenario, you know, the person who the children are living with during the school year, that's the work time. You're doing homework, you're getting them to soccer practice, you're going to open houses, you're going to sporting event. That's hard work.
yeah,
During those 8 or 9 months a year, 9.5 months, that's work. The other parent, who's the holiday parent, we'll call it, that's more fun time. Summer
yeah.
break, Christmas vacation, spring break. And very often, if you have shared custody, that's the schedule you're going to get, where one parent gets the work time, the other parent gets the vacation time. And
Mm-hmm.
so you got to think about that too. And it's hard if you're
Right.
stepping up and signing up for the work time. That's the laboring oar, I would say, versus the summer parent and the Christmas parent, where there's no homework, there's no reports due. There's it's so that's a really important point too. And people have to realize, especially if they have a shared custody situation, that's pretty much going to be the order. Unless you have
Mm-hmm.
a really outlier situation where one parent's really awful and the other parent's just granted sole custody year round, but that doesn't almost ever happen. It has to be
Sure.
really bad, such as in a case of, drug abuse or really manipulative bad co-parenting or whatever it is.
Sure. Sure. And then I have one other question for you, because you mentioned is it PA1 and PA2? Were
Yeah.
the social? Okay. So, and those are sort of more or shorter evaluations. Am I correct?
Yeah, it's sort of a fast track child custody evaluation. The
Okay.
PPA one is just a 1 day interview. It's probably about a half day.
Okay.
And it's sort of surface level, talks to the child, and just reports back to the court. The
Okay.
PPA2 is a 2 day process. It's supposed to be a little deeper dive into the facts. So they will contact third parties, like maybe a teacher or a friend's parent, or people you ask that person to talk to. But
Mm-hmm.
it's still very surface level, because you can't really ask too much from a social worker who works at the court, who has a bunch of other stuff to do, to do an extreme deep dive into a child's situation. That's
Sure.
more what a custody evaluation is for.
Well, okay. And so, on the subject of custody evaluation, so say there's a case that looks like it has a pretty good chance. A couple of attorneys come say, you know what, the parent who's moving away has really good evidence that they're the parent that does everything, blah, blah, blah. They have great reasons, for all the La Mouche, criteria.
Mhm.
But other parents say maybe a little vindictive or just doesn't want to lose. So what are all the possible things they can do to drag this on forever? Can they request a full custody evaluation that's going to last a really long time? What have you seen that are sort of the plays on the other side that try to stop this move from happening, even if they have a good chance of losing?
Yeah, if a parent does not want the move to happen, they can definitely slow roll it and ask for a custody evaluation, ask for um, and that's always the tension, right? Because one parent's always like, hey, gotta go. And the other parent's
Yeah.
wanting to really try to do everything they can to prevent it. And that's, again, that makes the judge's job tough, because the judge has to, at the end of the day, balance those two tensions against each other and decide. And it may be that the court says, oh, go talk to the social worker at the courthouse and do a PPA2. And by the way, the next availability is in 120 days from now or something,
Right.
right? But then
Yeah.
after that, I'm going to make a decision, or, I don't think I need an expert to weigh in on this. I don't need to hear from the child. Let's set you for a hearing. I'm available in 60 days. Come present your evidence, and then I'll make a decision.
Wow.
And, I think that lately I've seen that custody evaluations are falling out of favor a little bit by the court.
Okay. I've heard that more and more, which I'm
Yeah.
kind of encouraged by. But anyway, go ahead.
Yeah. I mean, they're expensive. They take a long time. Um, and at the end of the day, yes, you get a lot more facts and information from a custody evaluation. I think the process is valuable, but I also think the judges are pretty smart and they put their time in and learn kind of what's going on based on all the evidence that's presented to them.
Mhm.
So, uh, but again, to your point, if you want to drag it out, obviously a very good choice would be to ask for a custody evaluation and present as much evidence as you can, because that's your opportunity to try to persuade the court
Sure.
and get all that considered. So
Sure.
it's
Okay.
it's definitely a process. No two cases are the same.
Right.
And in fact, if you have the exact same case and you go to one judge, you could have a totally different outcome as you would from another judge, depending on,
Yes.
their view of how to apply the law. And by the way, both judges could be right and not appealable, because that's just their interpretation of the law and it's
Right.
within the range of what the law provides.
Yes.
So it's a minefield.
It is. It is. And that is such a good point, because I tell clients often, if they'll say, I spoke to two different attorneys and one said to do this, one said to do that. And I said, that is why it's called practicing law, just like practicing medicine. You might go to two different doctors and get two different opinions on what you should do, and two different attorneys they're practicing, they're taking the law and trying to apply it to your situation based off their experience or their knowledge. And we say that amongst my colleagues and myself. Yes, you take the same case, walk into three different courtrooms and come out with three drastically different rulings. So, there's a lot to it. And one last question then on this subject, Adam, can the ruling be appealed? And if it is, so say judge says, okay, you can move away, can parent appeal it? And then do they usually keep the child in place, like status quo, until the appeal is heard?
Yeah, that's a really good question. I have a feeling you know the answer, but basically, once the order is made and say the order says, okay, moving parent, you're allowed to relocate the child, right? So at that point, there's what's called a 30-day stay on the order. No move is permitted. And during that 30 days, if the non-moving parent wants to appeal and bring the case up to the Court of Appeal, that's their opportunity to do it. And it's a fast track process. It's not a 12-month appeal. It moves pretty quick because you've got custody rights in the lurch, and the Court of Appeal will get to it relatively quickly.
Okay.
But that's and if you're appealing, your best argument is going to be, well, hey, the judge didn't apply the law correctly. And in that case, because the Court of Appeal looks at that de novo, which means anew, basically. Hey, we look at whether you used the right legal analysis. And if they didn't, then the case gets sent back down to the trial level to redo it, right?
Wow.
Factually, though, if your argument is, well, the court just thinks didn't really do the best interest analysis, right? And hey, Court of Appeal, you should really do the best interest analysis over and tell us what's the best custody situation. Well, that's not the Court of Appeal's job. They don't look at the facts. They may, if it's so overwhelming, but it has to meet a very high threshold.
Okay.
So that's something that on an appellate situation, people are advised to talk to really good appellate attorneys who know how that process works, because that is an even more technical legal process than the trial level.
And thank you. That's a really good point, because I think people need to know, you need to go find an appellate attorney now. That's a very specific part of practicing law. You're right. And so you're not sticking with your same attorney anymore. You need to go.
Some trial attorneys will do appeals,
Okay.
but in my experience, there are people who only practice appellate law,
Right.
and they are oftentimes maybe a really good choice as well. But you never know. You just have to talk to your attorney and figure out what the next course of action should be if you find yourself on the wrong side of a trial order about a move away.
Absolutely. Yeah. Okay. Adam Schanz, thank you so much for joining me today. This has been hugely helpful to so many people who, like I said, come to me and say that they're thinking about consulting attorneys on this. And so I think this will answer a lot of questions, so they can either go in informed when they're consulting attorneys, or just help them make up their, mind at the outset if it's something they want to pursue. So I really appreciate it. It's ASCHANZLAW.com if you want to look up Adam and, consult with him. He's really good at a lot of other stuff just besides moveaways when it comes to family court. So again, I really appreciate you coming on. Thank you.
Great.